mention would be 1.31.10, the good character of the defendant. I think that the way that the evidence played out, specifically the defense put forth the evidence saying that these witnesses were fact witnesses and not character witnesses.
That there was some dispute about that. And in fact, don't you think it could be characterized as good character evidence? I believe that the state was contending that that was in part the case.
It was, and in the sense that it wasn't, so to allow them to get up in closing and then say, look, my clients were acting in the same way.
It was specific instances of good conduct, I believe, is what you were saying. And I guess the question is there any evidence to support it? I think that's a standard I have to use. And so, as a result, I'd like to give the charge Ms. Ball. The form of that charge is the pattern charge. Anything else on the state side?
Yes, Judge. I don't know. I don't think we requested. I'm not sure if the defense requested the statute of limitations charge. I don't know if it's necessary in this particular case.
Well, this gets to a comment that Ms. Andrews made earlier on about the dates being material allegations. As it relates to the categories of offenses. We've got November the 17th, November the 15th, we've got October the 20th, November the 10th, and we have October the 20th, November the 6th, I think. Generally speaking, the date ranges, though maybe others I don't think so. In any event, do you recall that?
From the directed verdict. Yes, I recall that. The state did request the charge, the dates in the indictment not being material, because that addresses that. The state is not restricted unless the dates are a material allegation in the indictment itself. Then the state is not restricted to the dates that are actually in the charge in the indictment. So
that's true, but then there's a requirement that they prove the offense within the statute of limitations. I think that the statute of limitations is is part of the state's request for charge.
If it was, I don't remember, but let me look real quick. I guess we did. But we also requested the dates in the indictment language, specifically in proving the time of the commission of an offense. The state is not, in a general rule, restricted to proof of the dates alleged in the indictment, but is permitted to prove its commission on any date within the statute of limitations, unless the indictment specifically alleges the date of the offense to be material.
Do you have that one there somewhere?
That was a state's request to charge 1.
Well, that's it. I'm happy to put that in. The state's request to charge 1. That must not be in one of the original notices that we got concerning the charge one, because I just don't see it. It's an oversight by my part. I'm happy to.
Sure, we had
accept that.
We had requested, and we had.
Do you have a copy of it?
Let me just write down for my notes the ones that we requested, and I'll be able to do them off the top of my head.
And the one you're referring to here is?
It's under the special, the state's request to charge 1 is the 4th page of the.
I see it. The state's request to charge number 1. I don't believe that we have this document. This might be a situation where it was filed, but because of our malware incident, it didn't make its way to us.
Okay.
And so I can tell you that this is the first time I've seen this.
And I apologize for that, Judge.
It's obviously not your fault. Yeah. It's a very unusual circumstance that struck the county. But in any event, I do think that this is a reasonable charge. State stage one, the objection stage one.
Was it filed in court?
It was file stamped. It's just that we didn't really have access to it because of the malware concern.
I understand.
And so it just wasn't brought to my attention that it had been filed.
It's an accurate statement of the law.
I believe that it's two. I'm happy to give this. Do I not have to give the statute of limitations charge in addition to that charge?
In general, no, you don't. It's weak.
Well, it says, but is permitted to prove its commission on any date within the statute of limitations. And
Correct.
so then they have to know what the statute of limitations are.
And I don't have a problem with it. I'm just saying sometimes it can be confusing. I don't have a big problem with it. It's not like a huge objection. I just know sometimes.
It has to be explained. It has to be explained.
I think the first question I would get back from the jury is, rather than say that state's permitted to prove its commission on any date within the statute of limitations, well, what is the relevant statute of limitations? And I agree, it would be better if we didn't have to do that. If we, I think I have to.
That's fine. I'll add it to my PowerPoint.
All right. And let me take a look at the, I guess I'll just ask you to go to the next charge that you're requesting. It's not in my packet.
The indictment, the conjunctive allegation charge, which reads, when an indictment charges that a crime is committed in more than one way, the state is not required to prove the commission of that crime in every separate way or method alleged. We must prove that the crime is committed in at least one of the ways alleged. If the indictment alleges that a crime was committed in more than one way, and those alternative methods are joined with the conjunctive word and, then the state must prove beyond a reasonable doubt that the crime was committed in one of the methods alleged, but need not prove more than one as alleged.
Well, I'm not sure what this is intended to capture. I know that the charges that I have on the offenses are track the language in the indictments. And is this related to a particular?
So for example, the murder counts, like the first 7 counts of the indictment, alleged blunt force trauma to the pancreas, liver, and mesentery. Let's say, for example, the jury is not convinced beyond a reasonable doubt on the mesentery for some reason. The defendant can still be convicted based upon the commission of one of those. They could find, but they do think that it was proven beyond a reasonable doubt as far as, let's say, the pancreas or the liver. That's what this language goes to. And I think it helps clear it up that maybe if there's one thing that they're like, oh, I'm not so sure, but what the indictment says, or what the law says, is that if it's proven in any of those ways, then the state has met its burden of proof.
Any objections, states two?
I think it's confusing. I think as written out, it's confusing. But I think it's an accurate statement of law.
And Judge, we can hone the language. Generally, I can tell the court when I address this in my closing portion of it. I just basically say "and" means "or" in Georgia. Like
That's what I've certainly been used to is
Yeah.
a statement that "and" means "or."
I'm comfortable just letting you argue, not giving this charge, if the party saying that this charge is confusing.
I always prefer to have the charge, that way it comes from the court, but if the court would like me to work on I can work with Ms. Mull on the specific language of this particular charge. I just, coming from the court, the specific law, I think that's important.
Well, I'm happy to give a version of it. If you want to talk about that, that's fine. Otherwise, I'll just give the state's request to charge 2, and you'll be explaining what that means.
Thank you. And as far as state's request to charge 3, this is a law that actually just came out from the Georgia Supreme Court this year that says that where crimes involve relatives with close relationships, slight circumstances can support the inference that the party colluded. We would be asking that would be added to the section on party to a crime.
I don't have a problem with that. it suggests that less than reasonable doubt is the standard when it comes to family members, and that's not the right statement of the law.
Well, and then just for the court, I can, this cases are Berger, V-I-R-G-E-R versus the state. That's 305 Georgia 281, came out this year, 2019. And then around the same time, the Supreme Court also released Solomon versus the state, 304 Georgia 846 219. It's not lessening our burden of proof. What it's essentially saying is that if there is this close relationship, then even slight circumstances can be inferred. And I pulled the language directly from, I didn't make this language up. This was the language, this was the sentence that I pulled directly from the Supreme Court's opinion.
Just because it's language that comes directly from the Supreme Court doesn't mean it's appropriate for a charge.
Well, I'll take a look at it and go from there. But we also have aggravated battery definition of useless or scheme.
Yes, Judge, and this would just be regarding useless does not mean that it has to be permanently useless. And I cite to Christensen versus the state, 245 Georgia Appeals 165, and Webb versus the state, 228 Georgia Appeals 624.
I don't seem to have any of these.
We provided a copy to you on July 8th of 2019 when we filed. But I can get another copy from this mall as well.
Well, this is consistent with everything that I've ever done in the area. I'm familiar with this case law. I think this is correct. It says, as it relates to aggravated battery, the term useless does not mean permanently useless, temporary loss of use offense. And I believe that's an accurate statement of the law.
And then state's requested 5, the court already given as murder in the second degree.
Oh.
Let's see if I...
Is there anything about the remainder of the charges that were back that I've submitted to you that gives you some pause or question?
Judge, in the venue section, 15110, we asked to be full. There's an extended charge.
There is.
That goes essentially that if it, let me get the back wording. That essentially if the venue can't be shown, that we can prove that it occurred in any, or let me get the example. I don't want to make it up here.
It's that second sentence in the first paragraph of the standard charge.
Yeah.
If you'd like me to put that in there, I'm happy to do it.
I think it might be helpful given the facts of this particular case. In a prosecution, in any case where it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Through the end of that section, I think would be appropriate given the facts of this case.
Okay, I can do that. I've taken out the premeditation charge because that's not something that is that the pattern charge committee thinks has to be given absent a specific request by the jury. So remove that. I've taken out the principal failure to prosecute other persons involved in the charge. I've taken out the prior conviction limited purpose charge. I've taken out the prior difficulty between parties charge. I've taken out the limiting instructions, purpose, parties, counts. I've taken out the statement charges. Statement of defendant standard of proof, statement of defendant voluntariness defined, burden of proof as to voluntariness, conditions precedent to consideration of statement, corroboration, defendant's statement, limited instruction, purpose, parties, counts. Those are the statement charges. I've taken them out because it seems to me that there's really no issue in the case as to voluntariness, there's no issue as to rights. There was counsel present during the giving of the statement.
That's fine. We put it in there, just you never know.
Out of an abundance of caution, I understand. And as well, you agree that they're not appropriate charges under the circumstances in this case?
Exactly.
There was an aggravated assault and statutory extended definition that I think was provided by the state, taking that out. That was the intent to murder, rape, fraud type of language.
I don't think we have that here.
And I've moved the malice defined for aggravated battery, which had its own separate charge. I moved it into the aggravated battery charge.
Okay.
And beyond that, that's the nature and extent of my work. Ms. Mulder, first of all, let me finish up with the state. Is there anything else that you're requesting that I've not addressed?
No, Judge, in my understanding from the additional 5, the conjunctive allegation will come in. It's just a matter of us working on the language, correct?
Yeah, it might make more sense just for me to leave it in as it's stated. If this is an accurate statement of the law, I think you contending that it is, and then you can address any perceived confusion during your closing to the extent that you deem that to be appropriate. So the only thing that I have really left is this Vigo versus the state case to take a look at and see whether or not that particular charge for the state's going to become language from recent Supreme Court case. Is there anything from you, Ms. Mulder? Everything's fine? Okay. And let me see. Let's talk a little bit about the length of time that we're going to be engaging in this closing argument work. Can we, and the reason I'm inquiring is because I, of course, would like to keep the closing arguments together if at all possible. Do the parties agree that that's advisable?
The state's fine.
Yes.
Okay, so why don't we just plan to start with the closing arguments at 1 o'clock? That way we keep everything together, we keep the charge with the closing, and it's all done this afternoon. So that gives me a little bit of time to sort of do this additional work that you have brought up regarding that one case, make a couple of little corrections, get you another copy of the charge, get your final feedback on the final product, and then just so that you know, I mark this as C1 and give it to the jury at the conclusion of the charge. So that they have it along with the table of contents to refer to the extent that they need to at some point down the road. Is there anything else?
Not from the state.
Are you limiting us to 1 hour, or is the capital case do not have 2 hours?
Yeah, I'm not limiting you to 1 hour. I think you have 2 hours under the first Supreme Court rules. Okay, thank you both. And just give me about 20 minutes to get this in final form and bring it back out to you. Thank you. Oh, do we have any objection to the form of the verdict form?
No, Your Honor. No.
Thank you. Language that I thought was confusing in the other charge where the two of you were trying to consult the conjunctive allegation. And in any event, this is what I come up with. just do the second sentence?
No. State's fine with that language, Judge.
Okay, so we'll use that then. I just printed off the dates in the indictment. That's the language that's going to be in the larger charge packet. Language is going to be the larger charge packet. And the reason I'm bringing it up to you in this form is because I want to give you a lunch break, and it's going to take a long time to actually print off the packets. I'm going to give you complete packets with these charges in at 1 o'clock. Okay. The venue, you'll see I've restored that language. I have not included the slight evidence charge. Taking a look at both of those cases, they appear to be Jackson versus Virginia analysis types of sections where we're seeing that language, so which is a post-verdict evaluation of the sufficiency of the evidence, and I think that there is a concern about whether or not it's appropriate to give this as part of the charge packet, where the duty is to prove the allegations beyond a reasonable doubt. So, is there anything else?
Nothing safe.
Okay, then we'll see you all back at 1 o'clock. Thank you.